Hi, this is Jones. One day, he got accused of killing somebody, and now he's under investigation. However, he doesn't know what he's gonna do because he's not knowledgeable of the law. So let's help him out. So let's start with the right to presumption of innocence. Every accused in criminal cases enjoys the constitutional presumption of innocence. That is, he is presumed innocent until otherwise proven. However, since it is only a presumption, it can be overcome, and the quantum of proof required to overcome the presumption is proof of guilt beyond reasonable doubt. Thus, an accused can be found guilty only if he is proven guilty beyond reasonable doubt. Where the state fails to meet the quantum of proof required, regardless of the weakness or even the absence of his defense, the accused must be acquitted. For any conviction must rest not on the weakness of the defense, but on the strength of the prosecution's case. Now, going back to Jones, is he gonna go to jail right after being accused of a crime? The answer is no. This is because no person shall be held to answer for a criminal offense without due process of law. From that proceeds the right of an accused to be heard by himself and counsel. The right to be heard would be of little avail if it does not include the right to be heard by counsel. This is so because even the most intelligent or educated man may have no skill in the science of law, that he may be convicted not because he is guilty, but because he doesn't know how to establish his innocence. Yet although an accused is entitled to be present and to defend himself in person and by counsel at every stage of the proceedings, it is also provided by law that rights may be waived. Thus, the rules of court provides that upon motion, the accused may be allowed to defend himself in person when it sufficiently appears to the court that he can properly protect his rights without the assistance of a counsel. Moving on, every accused has a right to be informed of the nature and cause of the accusations against him. The accused has to be informed of the facts that are imputed to him, as he is presumed to have no independent knowledge of the facts that constitute the offense. Thus, recital of facts is indispensable because the factor that characterizes the charge is the actual recital of facts. An accused may only be convicted of the charges under the information indicting him, and cannot be held liable for more than what he is indicted for. It doesn't matter how conclusive and convincing the evidence of guilt may be, but an accused cannot be convicted of any offense other than that charge in the complaint on which he is tried. To convict an accused of an offense higher than that charge on which he is tried would constitute an unauthorized denial of this right. Next, like every accused, Jones has also the right to speedy trials. That is, trials should not be unreasonably delayed. The rationale behind this are to prevent oppressive pretrial incarceration, to minimize anxiety and concern of the accused, and to limit the possibility that his defense will be impaired. Unjustified delays entitles the accused to acquittal. However, the right to speedy trial is relative, subject to reasonable delays and postponements arising from illness, medical attentions, and the like. Speedy trial means one that can be had as soon after indictment is filed as the prosecution can, with reasonable diligence, prepared for trial. Also, the aggrieved party, and not just the accused, is entitled to the same right. The accused is also entitled to an impartial trial, that is, the cold neutrality of an impartial judge. Judges should not be biased, not just for the benefit of the litigants, but also to preserve the integrity of the judiciary in order to gain and maintain the people's faith in them, the law, and our Constitution. However, just because a judge propounded clarificatory questions to the accused does not necessarily mean he is biased or partial. In fact, trial judges are accorded a reasonable leeway in asking questions in order to bring out the truth and to serve justice. Furthermore, the right of an accused to a fair trial is not incompatible to a free press. Pervasive publicity is not per se prejudicial to the right of an accused to fair trial. Finally, an accused has a right to public trial. This right belongs to the accused more than anyone else, for his life or liberty is the one at risk. This is to prevent possible abuses which may be committed against the accused. The goal of a public trial is to ensure that the accused is fairly dealt with and would not be unjustly condemned and that his rights would not be compromised. Going back to Jones again, while under investigation, he was not able to work. In the meantime, he borrowed money from his neighbor in order to feed his dog. After some time, the neighbor came to Jones to get the money back. Since Jones doesn't go to work yet, he was not able to pay. The neighbor got furious and urged the court to put him in jail. Now, will Jones be put to jail for non-payment of debt? The answer is no. This is because we have a right against prohibited punishment, which includes imprisonment for non-payment of debt. However, the debts referred to in the prohibition of imprisonment for non-payment of debt pertains only to liabilities arising from contract, but does not include damages arising from crimes. Back to Jones again. Hearings and trials went through. The verdict was in his favor. However, the investigators insist that there was an informant who just told them that Jones is indeed guilty. Will this affect the case? The answer is no. This is because Jones is entitled to the right to confront witness and to compulsory processes. Thus, extrajudicial statements of person who was not placed on the witness's stand cannot be considered, for it deprives the defense of its right to cross-examination. I hope we all learned some of our rights from the case of Jones. Thank you.